So, how many of you here have served on jury duty? All right. How many of you tried to get out of it? All right. Juries decide if a person is guilty or not guilty. They can also choose not to enforce laws that they personally think are unfair. That's called juror nullification. Today we have Hennepin County District Court Judge J. Quam, who is presenting on nullification and the rights and responsibilities of Minnesota jurors. Please welcome Judge J. Quam.
I'll be there in just a sec, okay? I want to make sure my video prop. All right, now I'm ready to go. Good afternoon, everyone. Thank you very much. My name is Jay Quam, as Julia said, and I've been a Hennepin County judge for about 7.5 years now. And I have to say, when Kara called me up, I was pretty excited about talking to you. Not just because it's you, because it's a jury. In the 7.5 years I've been a judge, I've come to really respect and admire our criminal justice system. It's got its flaws, I would recognize that. But what I would say is I firmly believe it's the best system of justice in the entire world. And it's good for a lot of reasons, but the reason that it's best is because of juries. So I love talking about juries, I love talking to jurors, I love having jury trials. It really is a special and very important part of our justice system. When I talked to Kira, though, I said, I gotta get back to you because I wasn't really sure if I could do this. So I found out talking to the people that govern judges' behaviors, and what they said is, sure, you can talk about the jury system, but just make sure everyone knows that if you're looking for the official word from the judicial branch, I can't give that to you. I can only give that, my perspective of this. So this is my personal perspective, it's my personal view, and I share it with you. And like I said, I'm kind of excited to be here because in the days leading up to this, you had a conversation with your friends, your non-lawyer, non-judge friends, and they'd say, what are you doing this weekend? And I'd say, well, I've got my daughter's dance competition. You've seen some of the dancers walking around. He said, oh, that should be fun. What else are you doing? And I said, I've got my son's baseball pictures and he's a baseball game. He said, oh, that should be fun. What else are you doing? I'm talking to the Libertarian Party about jury nullification. And it's like complete lame. And that was kind of disheartening. And what I'll tell you, I know that you guys are making progress. What I would tell you is you are so much better known than jury nullification that you've left them in the dust a long ways away, which disappoints me because I wish more people would know about the jury system and would care about the jury system like you do. So, you probably know this. What is jury nullification? It's a jury's deliberate rejection of the evidence. That's one part of it. And the other part of it, it's refusal to apply the law that's given to them by a judge. And I understand there's a lot of people that feel very strongly about this. You may have seen these types of pamphlets that go around here. And I respect people trying to educate people about jury nullification. Except when they add the language down there. Sometimes you see in pamphlets, and if you can see it, but it says nullification is your right to veto corrupt laws from corrupt politicians, and sometimes they add and corrupt judges. And I start to take that a little personal. But I understand where I'm coming from. I would say, I know I'm coming into the lion's den. You guys are way too nice and caring to be described as that, but I know where you're coming from. Your platform 18 says you fully support really the amendment, an amendment that would say judges have to inform jurors about the right to nullify a verdict, whether because of the evidence or because of the law. I understand where you're coming from, and I understand why you have that platform. For those of you that have looked at this, it has an incredibly long history and a very noble history. Starts out, there's a timeline here. I'm going to talk about some of the more significant events in jury nullification. It starts back 899 years ago. That was when the Magna Carta, one of the most important legal documents, was signed under some coercion of King John, if you remember that. And there was a lot of discussion. There's a lot of concessions by the monarch, which is unheard of at the time. And historians tell us that the area that was the most difficult to extract a concession from King John on was the right to a trial by jury. That's the Magna Carta. Someplace in there, is the right to a jury trial. I can't tell you where it is. But that was a thing that created this right that up to that point was really unheard of. As it turned out, though, over the next 300-400 years, the right to a jury trial got watered down quite a bit in the English system. They would impanel a jury, there would be evidence that's presented, and once the case was presented, you know what would happen? The judge would tell the jury what to do. And they could enforce what the judge said by saying if you don't agree with the judge's verdict, the judge can imprison them until they came back and came around to agreeing with what the judge did. And they could fine them as well. Until 1670, there's a case called Bushell's case. It wasn't about Bushell, the case initially. It was about a couple other people you may have known, William Penn and William Mead, a couple of Quakers. And they were out in the streets of London talking about the Quaker religion, which most of us would say is kind of a good thing, freedom of expression, freedom of religion. That wasn't such a good thing back in England in 1670. It was actually against the law. So they were charged with unlawful assembly, and they were clearly guilty of the law as it existed. So, after all the evidence came in, the judge said to the jury, okay, the evidence is in, now you guys go back to the jury room and come back with the verdict of guilty, just like the practice was. And you know what they did? They went back to the room, and they came back, and they said, in a historic moment, not guilty. So what do you suppose the judge did? Yep, the judge said, okay, I understand you may disagree with me at this point. Go to jail for a couple of days, be bound again, be deprived of water and food, and then come back and tell me that they're guilty. So you know what they did? They still wouldn't find them guilty. And at that point, the judge said, okay, I'm not going to push this any further. But what I am going to do, I'm going to find him not guilty. That hurts when you do this. But what I'm going to do, because by this time, he's pretty upset with the jury, right? So he says, out of disrespect for me, I'm going to exercise my right and fine all of you for disregarding my order. So he did. Locked him up and fined him. Most of the jurors, 10 of the 12 jurors, they paid their fines and they got out of jail. One guy, a guy who was one of my favorite people, he refused. Edward Bushell was his name. He wouldn't relent and he wouldn't pay. So he sat in this, and you can imagine what the conditions of jail were like back in 1670. Not a pretty place to be. He sat in jail for over 2 months while he worked his appeal way through to the courts until another one of my heroes, this guy, the Chief Justice, his name is Sir John Vaughan. He heard the case, and against 500 years of English practice, he came up with a decision that says jurors may never be fined or imprisoned for the verdicts. That is what really set out the principle of jury nullification as it has existed through the years. And it's thanks to that guy there. It was such a big moment in English jurisprudence as well as American jurisprudence. There's this plaque. If you go to England and go to their Old Bailey, they call it, it's their judicial complex. There's a plaque that commemorates the actual trial itself and the action that occurred to give the right of jury nullification. It's a big deal. It really is. That was brought to the United States. I'll go through the rest of these fairly quickly. Brought to the United States in a case with John Zanger. He was in Massachusetts, and at the time he wrote something critical of the government. 1734, that was against the law at that time, even though what he stated was true. So, as his lawyer Alexander Hamilton said, he's on trial for speaking and writing the truth. Really interesting trial, lots of chaos and disruption, but in the end, Alexander Hamilton would manage, before he got thrown out of the trial, to say, you should disregard the law that says it's illegal to honestly criticize the government. And in the end, the jury came back with a not guilty plea. And of course, it couldn't throw him in jail, it couldn't throw him in prison. That was it, but it was a very significant verdict at the time. It was so important, this right to jury that was being established or that was being recognized, that within the Declaration of Independence, I did find those, there's a couple of spots that identifies the king's abuses of the right to jury trial that were embedded in the Magna Carta, and identified how important it was to have a trial by jury. Those found their way into the Bill of Rights, which, if you look at it, there's about 180 words that are dedicated to the right to jury trial. I think there's 14 for freedom of expression. Kind of tells you proportionally how significant the right to a jury trial was. And it does have an effect going forward. Fugitive Slave Act. If you remember at that time, there was a law that said if you're in the North, it's illegal to harbor a slave who has escaped from the South. Lots of cases were brought. Lots of cases, the jury said, forget about this. Forget about the Fugitive Slave Act. We are not going to convict someone of harboring a slave. And what that did was really lead the culture to another one of the most famous documents in history, and that was the Emancipation Proclamation. A lot of people give the jury nullification and all those Fugitive Slave Act cases credit for bringing the country around to the point where they would accept one of the most important documents in our history. Continued on, Prohibition. A lot of similar cases, jurors would refuse to find people guilty of possession of or creation of alcohol. Labor leaders from the labor movement, same thing. Draft dodgers back in the 1970s. And then, some of you may know this. I don't want to sound like Ben Stein in the Ferris Bueller clip, but does anyone know this guy? Anyone? Anyone? That's a pretty famous, similar case. His name is Alvin Schlagen, and he was charged with selling raw milk. If you remember that case, generally, you may remember the name. That case, he was found not guilty. This is probably 3 or 4 years ago, pretty recently. This is a matter of not insignificance. Actually came around. I'm just off to the side there as he's giving this press conference and having the picture. He's having to come out of the elevator and head up the counter. I said, who's that guy? And they said, he's the raw milk case. I said, oh, okay. Sounds interesting. So I understand why people very much favor jury nullification. But what I have to tell you is there's a dark side to jury nullification that you have to consider before you go all in on the jury nullification principle. Okay? And I'm not saying you shouldn't. I'm not saying you should reject Platform 18. All I'm saying is there's another side to it, and reasonable people like you and I can disagree about whether it is. And here's why. See this guy? He's not the dark side of jury nullification. He is the victim of the dark side of jury nullification. That guy is named Emmett Till. He was born July 25th, 1941, died August 28th, 1955. And to say he died isn't really fair because he was brutally murdered. The brief story from Emmett Till, 14-year-old guy, he's from Chicago, goes down to Mississippi to see some family. And this is a point of significant disagreement among historians, but accept it if you will. He's accused of whistling at a 21-year-old white woman. You know, maybe he did that, maybe he didn't. But what you know is that the white woman's husband and his brother were there, and they didn't like that. Whatever the interaction was, maybe they just didn't like he was a 14-year-old black kid in Mississippi, close to a 21-year-old white woman. Whatever it is, what they decided to do started out by beating him, which is bad enough given that the worst he did was to whistle out. Didn't stop there. What they did after that, they decided to gouge one of his eyes out. They thought that was an appropriate way. And you think they stopped at that? No. They shot him. And of course they killed him, and they threw him off the Tallahatchie Bridge in one of the most brutal, senseless acts of racism the country had seen up to that point. So what happened? He was charged. He was charged with murder. Or the two were charged with murder. And it was cut and dried. I mean, this is, I would say, the worst lawyer in the world could present evidence that would justify a victory in this case. Just because it was that clear. But here's what happened. The best lawyer in the world couldn't have won this case because the all-white jury, after hearing this evidence, took 67 minutes, and that's nothing. And they acquitted both of these guys. And what's even worse, this is rubbing salt in the wound, one of the jurors said, they freely talked afterwards, and if we hadn't had stopped to drink pop, it would have been faster than that. And when you look at the principles behind jury nullification, this as much of an example of a jury nullification as the case of Bushel was. And of course, what's even worse is that afterwards, they're kind of out there. They're protected by another constitutional principle, double jeopardy, and you can't go after them again. So say, oh yeah, we did it and we kind of liked it. We liked killing this kid. That's jury nullification on the dark side of it. Another quick example, everyone probably remembers, at least everyone who's 50 years or older, Medgar Evers. Real famous civil rights leader in the early 1960s, kind of on par with, with Martin Luther King Jr. That's his son and his wife at his funeral. That's how he remembers himself. He was, as he was reaching prominence in the civil rights movement, encountered this guy here. Does he look like the white racist guy? He is. His name is Byron Dale Beckwith, if that's a name that sounds familiar to you. Dale Beckwith, I don't want to say he stalked Evers, but he killed him, and no doubt he killed him. And he was prosecuted in 1964. Good for the prosecutor to bring the cases. You kind of know how the story ends, don't you? Not one, but two all-white juries refused to convict Dale Beckwith. There's another story that the federal government, 27 years later, came back and they convicted him, but it gave Dale Beckwith 27 years of freedom that he did not deserve to have. All right, so that's the two sides of jury nullification. Where are we at in Minnesota? There's a case. Every case in the union just about has this, State versus Perkins. That's where my Minnesota Supreme Court, the rule that I have to follow, I'll read this to you. It basically says you don't have to tell, or you shouldn't tell a jury of this right that is really built into a jury system to nullify. That's built into the way we process cases. If you go on the website and say, I want to find out what juries do, you pull this up over your jury service. It's kind of hard to see. At the very bottom, I'm trying to highlight it for the people who can see. It says in each trial, the judge determines the rule of law that governs the case. And of course, nobody reads that stuff when they come up for the jury service. But if you get selected to be on a jury panel, you're going through that question. The ones of you that are here, you probably remember this. First of all, we make you swear that you're going to tell the truth. So if you lie, you're subject to perjury. And then we say, or I say as the judge, do you understand you must follow the law as I give it to you, even though you think the law is or should be different? That is a question that is designed specifically to identify people who are kind of enthusiastic about the right of a jury to nullify a case, at least based on what they see as inappropriate law. And of course, you swear that you're going to try the case according to law as I give it to you and as the evidence suggests. So if we kind of really get you to identify whether or not you will accept the laws of the case. So what it leaves you at is really this. So as I'm swearing you in to take your seat as a juror, blah, 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 and to base your verdict on the evidence and the law. And you'll see that the guy here has got his fingers crossed saying I do. That's the only way, really, someone who's a strong believer in jury nullification can get on a jury, is to lie under oath. And I know that's a very uncomfortable thing for people with pretty strong principles like yourself. And like I said, I didn't mean to give it a spoiler alert, but I believe the system we have is a good system. First of all, as I mentioned at the very beginning, I really do believe it's the best justice system in the world, especially in a criminal context. Right now I'm in a serious felony rotation where people are looking at crimes where they can spend years and decades and maybe the rest of their life in jail. And you hear cases. Most of the cases are ones where did he do it or didn't he, or did she or didn't she? And as much as I'd like to say the answer is obviously clear, it's not. And when you're dealing with consequences that are so significant, it's hard to make that decision to say the person is guilty. It's easy to say what the law is because the law is there. Making that decision is a hard thing. And to spread the responsibility out among 12 people, it was a brilliant way to have a decision that was coherent and reliable and credible. I like this, and jurors do as well, because my job is to define the law and try to rule on the evidence as it comes in, as it should, and then to give the tough work to those that are really better able to analyze the evidence than I am. And it's not just me that sort of likes how this works. I talk to jurors afterwards, and it's a really fascinating thing. I know the folks that were on jurors here got a chance to talk to judges, but the judges love it. I love talking to jurors. And I asked them about service, I asked them about what they thought of it, and they have told me, I don't talk about jury nullification, how would you like to have this added layer of responsibility? I don't do that. But in the end, they look at the system and say, I really have confidence in the system now. And really, when you look at it, there's not a lot of Bushel cases, Zenger cases, Schlagen cases. Those are the ones maybe that make news, but there's thousands and thousands of other cases where nobody really disagrees about whether or not the law is as it should be. The question is, who did it? It really is a factual question. So to the extent that you want to push the jury nullification issue, you're really potentially affecting the vast majority of cases that go on without a jury nullification issue obviously present in it. So, bottom line, why I don't like the idea of giving people giving juries the explicit right to nullify is that it defeats the rule of law, because the instructions I would have to give them would make the law, whatever it is, whether it's rape, whether it's murder, whether it's assault, whether it's domestic assault, it would make that really as much guidelines as anything else. And it would be giving jurors really the ability to say, come back and do what's right, whatever that is. And we've got a group of people in Minnesota that is diverse as it is. In my courtroom, I could be trying a domestic abuse case, and they may find them guilty because they thought that they should. In the next courtroom over, you get a different group of people with a different orientation toward consensual sex or domestic abuse. Maybe she deserved it. I mean, there's all sorts of things where the very same case would be seen by different groups of people differently. So one person would be convicted and the other wouldn't. And in the end, this is probably the thing that makes me most concerned about jury nullification. It makes it a rule of one. And that means, under the Constitution, as you know, in order to convict someone, all jurors have to be unanimous. And of course, to acquit someone has to be unanimous as well. But as a practical matter, if one person says, I don't like that result, for whatever reason, they think drugs should be illegal, they think a husband should be able to rape his wife, pick anything, should be able to drink and drive, and people have all sorts of views that are consistent with those types of outcomes. As long as one person says, I'm not going to do it, and the judge says I can do it, I can hold this view until he declares the jury hung. As a practical matter, there are going to be a whole lot fewer convictions of people that don't deserve the freedoms of walking around. Because practically speaking, you're not going to keep trying these folks until you get 12 people that agree on a verdict. So my concern is that there would be a lot fewer people that would actually meet the responsibilities and get the consequences that they deserve. So, unless you have questions, what I want to say is thank you for being here. Yes, sir.
You said something minutes ago. You said, I don't like giving jurors the right to nullify.
Yeah.
Do you have the right to give jurors a right?
No, I probably didn't. I don't give that. I don't take that. I mean, it's there.
Okay.
You get 12 people in the room. Everybody knows it. I don't know what's going on there. I can't tell them what to do. I can't tell why they did what they did. It's something that there's no way we can take that out of the system.
So you don't like telling jurors about their rights?
I would say that's probably.
So you have a more ignorant jury pool, and that's what you want, right?
That's a point where we disagree. I think you would probably say you should educate them about this right, and I would say that is a miseducation or it's a misstatement or, I think we've probably come to the end of our discussion, right? I mean, I understand what you're saying. Yes, they can do whatever they want as long as they get together and do it, and I can't control that. I can't throw them in jail, and I wouldn't throw them in jail, but right, that right exists there.
Do you think jurors have the right to judge the law itself?
If you're asking me that, my personal views, no, I don't want them to first pass on whether the law is a good one or not, because of all the reasons we said. Because if you get one person that says, I don't like the idea that the law says a man can't have sex with his wife anytime he wants to, in any way he wants to. There is that view out there. I will tell you that. And that could lead someone who has raped his wife to be, essentially set free. You can disagree on that. Yes, sir. Or yes, ma'am. I'm sorry.
In the Ron Mill case, it sounds like that was a case where the jury went against a law. Is that right?
I don't know enough about the facts of it to
I'd
say
like to know
whether or
more
not
about
there was a disagreement about what the underlying facts were,
Okay.
or whether they completely disregarded the law. What I know is that the people that advocate for jury nullification see it as a victory for jury
Okay.
nullification.
One of the things where I think the reason I can support you is I understand your argument, having sat in a jury. But I'm wondering if by educating the public at large and not by using strong words like corrupt judges. And as a libertarian, I object to those words because I think it makes us look too far out there. I like to use a gentler approach to education. But using that, and when people feel so strongly, as they did about, for instance, the Slave Act, that their conscience just won't let them apply the law in that way. So you don't have to, so basically I like the idea that you can't convict them if their conscience drives a decision like that. So I think that there are protections either way, right?
Yeah, you know, in the end, jurors are very thoughtful people. If you've been in the jury, you know how seriously they take their job. And I have no doubt if they don't think that the outcome should be guilty, whether because of the law or the facts, I would say as a practical matter, they figure out their way to get there. And that may be what happened in the Schleifer case. You know, we have to do the right thing. It drives me in a lot of ways, but it also, I think, drives a lot of juries in a lot of ways. Yes, sir.
What is the result of a nullification? Is it just a hung trial and then it has to be retried?
You know, it depends on whether it's a hung jury or whether it's a unanimous jury. You know, if everyone agrees we're not going to convict, there's an acquittal and you can't try them again. If one person says, I'm not going to vote for conviction, then it's a hung jury and it's up to the prosecutor to decide whether to go through the whole process of retrying the person or not. And typically they choose not to do that, is what I would say. So the effect is the same. There's never a conviction. So, wow, there's people that are asking questions here. I love that you guys are interested in this stuff. It really is awesome. Yes, sir.
My thoughts are that jury nullification actually has more importance in the appellate courts than it does in the initial courts. And I say that because we have a system of law based on stare decisis. Jury nullification to me seems to be the counterbalance to stare decisis, meaning let the law stand. So if we go back in history, we look at the civil rights era, and we look at the Jim Crow laws. And as cases would come up, lots of judges or lots of juries in our courts would use stare decisis to continue perpetuating what was necessarily a bad law. Having jury nullification, I think, counterbalances that, and when you get into the appellate system, the jury can, in effect, nullify the decisions that were made previous to it. So that's why I think jury nullification isn't just out of hand a bad idea. It's something that's a tool to be used along with everything else.
What I'm saying is, I'm not saying that jury nullification in some cases is a bad idea. I'm saying as it would be applied in court, I'm afraid, and as it has been applied in court, it can have worse consequences. It can get you more further back than it does forward when you've got other recourse for changing laws that are unjust. You know, that's just right. Yes, sir.
Not so much from a philosophical standpoint, but from a practical standpoint in Minnesota, I understand that jurors are told, not asked, but told and then have to give swear that they will obey the judge's rules, how they lay out their court, that they have to make a decision based on the law, not so much of jury nullification. But in the case of the Minnesota Melt case that you talk about, it seems to me that they aren't following the judge's rules. Did they get in trouble? Could they get in trouble? You see what I'm saying?
I can answer
conflict.
I can answer the question, did they get in trouble? They can't get, no, I mean, they can't get in trouble.
But they didn't follow the rules. They were instructed and swore.
Yeah.
So it's kind of like, I just instructed and swore, and now we're gonna let them off, and now we're considered kind of heroes.
Yeah, so if they swore that they'd apply the law, as I gave it to them if I was a trial court judge, and if it was established beyond a reasonable doubt that they deliberately disregarded the law and violated their oath to me, they could, I suppose, maybe be charged with perjury, but I will tell you there's a better chance. I think that the sun will rise in the west tomorrow morning, and some juror will be prosecuted for handling him or herself in that situation. First of all, it will never come out that that's what happened. I mean, that's
Well, if they bragged about it afterwards.
Have you heard anything, any negative consequences coming to him from the legal system?
I don't know.
No, I mean, and it's
But
a practical matter.
it seems conflict, it's in conflict.
Why do you even need jurors if?
Oh, are you kidding?
Well,
Oh, yeah.
wait, if they have to follow the law as you tell this to them, why do you need people with consciences?
Oh, man, because you should come into, well, you should come into court sometime. The hard decisions generally are not, you know, it's against.
When it
if you
comes to
find-
victimless crimes though, I understand with murder and rape and obvious harm to people or property. What about marijuana and prostitution and lots of, there are no victims.
Yeah, I mean, in that case, sometimes within the prosecution context, there's a question about whether or not there was entrapment or other things that really a jury is best able to assess. You know, the factual disagreements
Well,
is
but
where you
that's
need
still,
to.
that's not about the law. That's about if a cop did entrapment. It's minutia. What if people hate the law and it's a bad law? It's hurting our society.
Well, I mean, what would happen in Minnesota today if someone said that in the jury selection, we kick them
You'd
off,
kick 'em
whether you
out.
should or not. Yeah, I mean, and I understand what your view is about whether that should happen. I mean, I respect your view. We disagree, but I respect your view. I mean, I know where you're coming from on that. But what would happen today is we kick them off. We wouldn't allow them to be on the jury.
So you don't want thoughtful people on the jury. I'm
What's
sorry.
that?
And
No,
that's-
that's not true. You know, and I just want to emphasize how hard the people who have been on jurors, it is a hard job just dealing with the facts. You know, so it's not like they're just a bunch of potted plants that go in there and do what I tell them to do.
But he's kind of got a point, he's kind of stacking the deck in your favor, how you like law.
You know, I understand where you're coming from. You know, whether or not I'm in favor of these laws or not. You know.
Would you be, I like this discussion, I like to hear your answers. Would you be thoughtful in taking some of these people on that might challenge the law?
Let me just ask Karen, you know, I know I only have a limited amount of time. Give me the hook when you need to give me the hook, okay?
We have like 2 minutes left.
Okay, but like I said, give me the hook when you.
You know what, we'll do one more question.
Okay.
I got one question, being a first-year law student, I've got to ask.
Oh, you are first year law student, good for you.
So, one of the first week of class, they make it real clear. Judges give the rule of law, juries interpret the law.
I like that.
Yeah.
I'm sure you do.
So my question is, if that's what they're teaching us, supposed to be, you know, good or bad guy lawyers, it seems to me that when, in all of your presentation, it was a really good presentation, the one thing that I got hung up on is when you kind of made the point of the rule of one. The whole reason we have 12 people is because it would be very hard to find 12 people that would all be in agreement that raping your wife is a good thing. So I don't think we have an issue with the rule of one. So that kind of defeats that part of the argument for jury nullification.
I guess I don't understand the point.
So when you said that with jury nullification, it could evolve into a rule of one. One person gets to make a rule, which could be the dark side, right? When you gave the example of a person that was not sitting on a jury, and through jury nullification, could say, oh, it's okay if we rape a woman. My point is, it doesn't work like that. There's a flaw in that premise in that we don't have juries of one.
No.
We have juries of 12.
What I'm saying is, you know, if 11 people think it's a really awful thing to rape your wife, and one person on the jury does, you can't convict that guy of raping his wife.
I agree, but that's going to happen regardless if you have jury nullification or not. You haven't gotten all 12 people, and we as a society have said that, you know, we think 12 is a good number. This is how many people it takes to do a conviction. You have to have complete agreement by all 12. So you can have a hung jury, but what you don't have is an acquittal. If you have a hung jury, then it's up to the judge to make that decision. Well, are we going to, you know?
But it's the prosecutor that makes that decision. Yeah, and you know, maybe we're going like this on this, but what I would say is that if I would, you know, through the screening process, we talked a little bit about the voir dire process, and maybe that one person who believes you should be able to rape your wife is not honest with me and the lawyers, and said, you know, because I will ask them, you know, the context of the law will come up, and I will ask them questions that are designed to ferret out the view about whether or not you believe that whatever the law is, a man should be able to rape his wife. And if he says no, there's nothing I can do. He's lied to me, you know.
Right, and that's my point, that if you've already gone and you want your jury, you've got your standing jury, they listen to all the facts of the case. Now they're in the room deciding upon the evidence that's been presented. You've got 12 people, and by what you're just saying now, I think that actually goes more to promote the idea of having jury nullification, because you've already put those checks and balances in place before they've even sat in the room. These are 12 people that both the prosecution and the defense and the judge have all agreed upon to say, these people are of right mind, they've sworn that they are going to listen to the testimony and apply the rule of law. But at the end of the day, if they think that the law isn't applicable, or in the case of the Jim Crow laws, it shouldn't be like this anymore, and we're not going to be able to change this through, representation or statutory, other statutory means, we now as a jury have the power to nullify that which what we think is wrong. And I think that's
Okay, I'll let Judge Quam respond, and
I
then we
do.
are.
Yeah, I'm not sure, I need to respond. I understand your point, and I respect it. So, thank you very much. You've been really a fun.